Yes, good morning, Mr. Barnes.
My Lord, good morning. If it please, in this matter, I appear on behalf of the appellant journalists, Miss Tickle and Miss Summers, who accompany me in court, and I'm assisted by Mr. Nottage. I wondered whether, prior to the broader introductions, and apologies that I'm causing all of the court to strain off to the right, I didn't know whether the court might wish to deal initially with the question of the reporting restriction orders that are in force pursuant to the order of my Lady Justice King.
Deal with in relation
Well,
to that.
I think simply to flag that order is in place, and as I understand it, has also been published on the judiciary website, so should be available generally. And I have also been asked, simply for the avoidance of doubt, to clarify that the intention of that order appeared to be to facilitate any live blogging of these proceedings, and that included the potential to rely on the skeleton arguments that were embargoed up to the point of this hearing commencing. And I hope that that's satisfactory as a framework for the court.
Yes, yes.
Thank you very much. In terms of the broader introductions, obviously the matter is an appeal from a decision of Mr. Justice Williams announced on the 9th of December, reflected in an order of the 11th of December and maintained following a review on the 13th of December, and considered in a judgment dated the 19th of December, ultimately published, I think, on the 20th of December. And the appeal is with the permission of my Lord, Master of the Rolls, granted on the 19th of December in respect of 4 of the grounds. Pursuant to an order of my Lady Justice King, the appellants were permitted to rely on amended grounds, but the additional ground, the question of permission, arises as part of the hearing today. For my part, I intend to address it in the course of my submissions, unless the court wishes me to take a different approach.
Yes, that's fine.
In terms of broader introductions, Mr. Wolanski, King's Counsel, and my friend Mr. Rowe represent the bulk of the other media parties who are obviously known to the court. That includes the BBC, who made the earliest application in time. They were subsequently joined by a number of other parties at or about...
They were subsequently joined. There was a C2 issued by the BBC.
Yes.
How did the other parties come to be parties?
There was, as I understand it, an application that was made in November. For those other parties, I apologise if...
No, we haven't seen it.
Apologies if that doesn't appear. We'll obviously
could
see...
somebody just get us, we don't have to discuss it now, but
Thank you.
somebody get us the paperwork that shows how the other parties became parties?
Yes, I think in essence they sought disclosure of the material that had been provided pursuant to the February 2024 order, and ultimately were represented alongside the BBC.
They sought disclosure informally under the practice direction.
No, I believe there was an order that was made.
Well, if there's an order or an application, we'd like to see it, please.
Thank you, of course.
That's all right. Thank you.
I should express that I'm grateful to Mr. Rowe for having taken on the preparation of the authorities bundle in the course of the appeal. In terms of the media parties, the other party that was represented or was present throughout the proceedings before Mr. Justice Williams is PA Media. They have filed written submissions prepared by Miss Glass, who appears in the press section of the court. I don't believe that Miss Glass intends, unless invited or there are any questions, to address the court specifically, but she's obviously in attendance to assist. And for the avoidance of doubt, all of the media parties, as my lords and my lady will be aware, support the appeal. The local authority in this matter is Surrey County Council. They're represented in this court by my own friend Miss Fottrell, King's Counsel, and by Miss Cayune. In the court below, Miss James also appeared. The court will be aware that they support the appeal on a procedural basis. They adopt a slightly different, distinct position in relation to the applicable balance, but as I understand it, don't support, notwithstanding those submissions, the sustaining of the order. The other respondents to the appeal, my learned friend Mr. Narazadeh, along with Miss Wigger, appear on behalf of Sara Sharif. I understand that as with Miss Batul, there's been no request for his attendance, whether in person or remotely, and the court will be aware that Mr. Sharif opposes the appeal. Just to add a little spice to the introductions, Mr. Tyzak is now next across the front row. We're obviously very grateful for the speed with which the Attorney-General responded to my Lady Justice King's request as of Friday.
Lightning speed, I would say.
Indeed, and I should say that Mr. Tyzak was not only in communication over the weekend, but indicated very helpfully that he intended to file a document, which I know wasn't directed by my lady, but is obviously helpful in terms of understanding the position.
I thought that would be a step too far.
Following on, my learned friend, apologies, I should say that Miss Cullis accompanies Mr. Tyzak. Miss Batul is represented within the appeal by my learned friend, Miss Brereton, leading counsel, and Mr. El Ghardi. On behalf of Miss Batul, they have filed a position statement which expresses that she is essentially neutral on the appeal. I think, again, Miss Brereton is here in the event that the court has any matter that it wishes to call upon her for. And then, finally, I think, my learned friend, Mr. Verdon, King's Counsel, who I think of the parties was also not see before the court when Mr. Justice Williams was hearing matters, leads my own friend Miss Fawkes, who did appear in the court below, and again, as I understand it, they don't seek to advance a position on the appeal and adopt a neutral stance, albeit I think seeking to assist the court with expanding the range of arguments in response to the appeal. The court will also be aware that there was a note prepared on behalf of the 3 judges who were impacted by the order of...
May I say
yes.
That we suggest that in the course of this hearing, we refer to those 3 judges as Judge 1, 2, and 3.
Thank you.
And that the court should take no notice of any gender-specific pronouns used in relation to those judges.
Yes.
It is to be assumed none of us know anything about their identity.
Yes.
It would be preferable to refer to them as they, but if anybody uses a gender-specific pronoun, it is not to be assumed that that is correct. We'll talk Judge 1, Judge 2, Judge 3, and they.
Thank you.
That'll be that.
My Lord, there is, as the reporting restriction order notes, one largely administrative order that was made by a bench of magistrates. I'm not aware that they were notified. I'm not sure whether they're necessarily identified.
I don't think they were notified.
No.
No. And you said that they issued a statement, which they did through counsel.
Yes, the note. Yes.
Mr. Purchase and Miss Reeves.
Yes, indeed.
Are they attending, even in a noting brief capacity, or not at all?
No. I am aware that they are not instructed to attend.
Right.
What I have sought, the issue arises in relation to both the argument prepared by the advocate to the court and the note as to the degree to which those may be published and or released to the media or others.
Yes.
That appears less potentially controversial in relation to Mr. Tyzak's written document, albeit I think the order strictly confines the release of skeleton arguments via the Judicial Press Office or otherwise to the parties to the appeal. In circumstances where the advocate to the court has been appointed and contributed to the arguments in writing, we would suggest that that skeleton argument, suitably redacted as required, should also be made available.
What about the judge's note? Why not?
Well, in principle, I, on behalf of the appellants, and as I understand it, the other media parties, would support the release of that note and indeed raise the question of the...
Have they been asked?
I have communicated with Miss Reeves this morning to seek to understand the position of the judges on that request. There is undoubtedly information within that note that is not otherwise published and would unquestionably need to be redacted in the event of publication or release.
There is a position adopted in that note, which presumably must form part of our consideration because it's been made as a submission to the court.
Yes, Respectfully, there are a number of matters arising from it that I would certainly seek to refer to in the course of this hearing. I suspect that's a different question to the question of publication. And as I say, I anticipate...
But I mean, once you refer to it, it's public.
Indeed.
I mean, obviously, if you're not permitted to, you won't. But I mean, it seems to be anyway, and we'll talk about it if we need to. Unless there's opposition from anybody, it seems to me that it's part of the case.
Indeed. I don't think there's... I don't understand there to be opposition to it being referred to, and I think most parties, who wish to refer to it, positively see its contribution to the broader contours that the court would be considering. There is a discrete question as to the release of that to the media, given it doesn't constitute a skeleton argument. And as I say, I suspect on any view it is likely that redactions would be required as to some of the information contained.
I accept the redactions point, but if it's something we're being asked to take into account, it's as good as a skeleton argument. You agree with that?
Absolutely.
Yeah. So I think unless there are objections that any counsel in court or counsel out of court want to make, that can be disclosed subject to appropriate redactions in early course. Through the press office, yes.
Thank you. I will obviously seek to convey any response that I receive from Miss Reeves, who I'm
subject to any request not to do so, and the same goes for Mr. Tyzak's helpful note.
My lord, yes, I can't see any reason why that shouldn't be published. Save us to make clear that obviously I'm appointed by the Attorney General, but not instructed by the Attorney General, so I'm not expressing a case or putting forward a case on behalf of the Attorney General.
Right, you're appointed but not instructed.
Yes.
Are you
yes,
instructed by anybody?
I'm not instructed by anyone, no.
You're just a sort of free agent.
Free agent, here to assist if I can,
Okay.
but that's
Thank
the
you
limit
very
of the
much.
role.
As far as the judge's notice is concerned, I would have thought it's only about 15.
Yes. Okay, good.
Thank you, my lord. Turning then to some of the slightly more prosaic matters, I hope that the court has 3 fully functional electronic and paper bundles as relates to the court's preference. The core appeal bundle is of 295 pages, the supplementary bundle 150, and the authorities bundle, which, as I say, was very kindly prepared by Mr. Rowe, of 415 pages. I have also, this morning, arising from the receipt of Mr. Tyzak's note, had emailed across to the court 2 authorities, one of which he refers to, which is the decision of Mr. Justice MacDonald in X and Y, and the other is a decision of the court in Strasbourg in NS and Croatia, which Mr. Justice MacDonald refers to, and which has a helpful summary at paragraph 94 of that judgment, which in due course I'll refer the court to.
Yeah, okay.
Thank you. My lords, my lady, there are then 2 preliminary matters that are more substantive and are pursuant to applications that are before the court. The first relates to the application made on behalf of the other media parties to be treated or deemed as appellants in the matter, and the second is the application made on behalf of Mr. Sharif to admit evidence in the appeal that appears...
Well, let me just tell you where we are preliminarily on those 2 points. First, if you want to become an appellant, you have to file an appellant's notice. And that's really the bottom line. You have to pay a fee as well. What do you want to do?
We're happy to undertake to file an appellant's notice.
You have what?
We're happy to undertake to file an appellant's notice.
Right, in the same terms as the amended notice?
In the same terms as
Yes.
the
Okay,
amended
well,
one.
if you undertake to do that and to pay the fee, subject to anything my colleagues may say, we're happy for you to become appellants.
I'm grateful.
But subject to the not deciding the question of ground 1B, so you can have permission on all the rest, but you can't have permission on 1B because we're going to roll that up, decide that in the judgments in due course. Okay? Right, that's point 1. The second point, as regards the application to admit evidence, I would have thought the most sensible course is to look at that evidence. We've already looked at it anyway, de bene esse, and decide again in our judgments whether it's to be admitted or not.
Yes, and my lord will have seen a response from the media parties which
Yeah,
broadly raises whether it sufficiently meets the
and
standard
you
in
can
London
all argue about it.
I
Say to your heart's content, but I don't mean that. Modest.
I'll try not to belabor that particular focus of the appeal, but we, as you'll, I hope, have seen, the appellants filed a short note in relation to that, in accordance with the direction of my lady.
You've seen all the notes in respect.
Thank you.
But, you can deal with it at an appropriate stage in everybody's submissions.
Thank you. I think then, unless there are any other matters of preliminary matters or housekeeping that the court wishes me to address, that I'm content to then turn to the presentation of the appeal.
Yeah.
Thank you. My lords and my lady will be aware that the appellant's skeleton argument appears within the core bundle at page 19. And I wanted at the outset to address how I intend to address matters on behalf of the appellants. I initially wanted to deal, albeit I suspect the court are now very familiar
So
with
you're going to have to keep your voice up a bit because you've
Yes.
positioned yourself far away to the right-hand side. Of the
I think by force of circumstance, but yes, I will endeavour to.
The last to arrive gets the worst place.
Or the first to appeal. Initially, I wanted to deal briefly with some of the background matters and the chronology, the case, the process, setting the ground in terms of the restraints applying in family proceedings, and to set out my stall. I'm conscious that my Lady Justice King invited the Attorney General to appoint an advocate to the court to consider the question of judicial anonymity in the context of family proceedings. But at the outset, my fundamental submission is that there is nothing in fact that distinguishes family proceedings from any other proceedings, and that...
But the law does.
Not in relation to...
12 of the Administration of Justice Act 1960 and Section 97 of the Children Act 1989 do distinguish family proceedings.
I say not in relation to the anonymisation of judges, and that's the critical distinction. But that was why I was intending to set the ground in terms of the restraints and then move to the question of judicial
I mean,
anonymity.
just to be clear, Mr. Barnes, anyway,
Yes.
speaking for myself, one of my overwhelming concerns about this case is the question of jurisdiction. Courts have to act on the basis of appropriate jurisdiction. And the first question any judge, it seems to me, should ask themselves when they're thinking of making an order, particularly of their own motion, is, do I have jurisdiction to make this order? And I would certainly be grateful if the parties could consider what their answer to that. And it seems to me that the time, the critical time at which the judge has to ask that question in this case is the 9th of December. I think it may be late in the afternoon, when for the first time the question is raised by him and he says, I'm going to make an order anonymizing the judges. And at that point, does the judge, question, I don't know the answer, you're going to tell me the answer, does the judge have jurisdiction to make that order, and if so, on what basis?
Yes, I'll certainly seek, as far as I can in the course of the presentation, to assist with that. I think what is notable in terms of the procedural approach of Mr. Justice Williams in comparison to the decision of Mr. Justice MacDonald in X and Y is the rather more careful, and we would submit procedurally appropriate approach taken by Mr. Justice MacDonald, who invited to make anonymity orders on behalf of a guardian, but seeking to expand that to the professionals, said, I simply have no application. I don't know the position of the judges, and I'm not in a position to consider that application.
That wasn't a judge case. That was a guardian and other professional.
It was, though the guardian sought initially to include other professionals, namely a social worker, and the trial judge in the compass of the protection that was sought.
Okay, but he didn't make that order.
No, he didn't. I think the point I rely on in X and Y, which Mr.
Procedure.
Is that Mr. Justice MacDonald, with an active request, albeit he was concerned about the basis on which that request was being made by somebody who didn't represent the trial judge, took the approach that that would not be an appropriate step, albeit in the course of his judgment he considered some of the conduct that in that case had been directed towards the professionals by the father concerned.
Okay.
So I certainly respectfully agree. One of our broader concerns is the combination of deep procedural laxity combined with an extraordinary order on which the basis of that jurisdiction is undoubtedly questionable, and the capacity of the judge, particularly having not actively invited submissions to
You say it's questionable, but one can imagine circumstances where such an order would be appropriate, or might be appropriate if, for example, it's not this case, but if there were positive threats against the judge and an application to anonymise the name of the judge properly made, either to protect the child in the wardship or children in the wardship proceedings, Article 2, Article 3 rights might come into play, and they would have to be weighed against Article 10, right, at that point, if there was such evidence. So that's one possibility where such a thing might be done perfectly legitimately. I imagine you would agree.
My Lord, if it helps the court for me to set out my stall.
Yes, it does.
At the outset, where the appellants express particular concern is in the application of prior restraint through the prism of the Article 8.10 balance in this particular case. We absolutely recognise the very serious conduct that can, on occasion, be directed towards.
But why do you say Article 8? I mean,
No. What I'm coming to is we fully accept that if the risk engages Articles 2 or 3, then the nature of the positive obligation that may well arise might impel a court to take that step, or indeed some appropriate public body, whether it's the MOJ, HMCTS or so, to apply.
Deliberately using Article 2 and 3, not Article 8.
Yes, indeed.
Because it seems to me that that's a very different situation.
And we agree.
Yes. So the question then is, when does Article 8 become engaged on behalf of a judge sitting in public, in a public court as the emanation of the third arm of state? How does Article 8 become, those Article 8 rights become engaged, and at what point?
Yes.
What circumstance?
Before engaging with that, respectfully, entirely appropriate, that is precisely the terms in which we pursue the appeal. What I would want to flag is that there is also the possibility of an order under Section 4.2 of the Contempt of Court Act, where the administration of justice might be interfered with. And I wanted on that basis, having set out the stall that we weren't aware of any order being made in relation to judicial anonymity, to draw the court's attention, I hope appropriately, to the fact that within the appeal that was ultimately heard by the President and Lord Justice McFarlane in relation to the W case, where findings had been made without notice to a social worker and police officer, what is plain within some of the subsequent procedural judgments of then the President, Sir James Mumby, is that there was an order made there under Section 4.2 of the Contempt of Court Act 1981. What I haven't been able to discover is the basis on which that was made, but that appears to the appellants to be another route by which there might be a grounded basis for potentially justifying the order, if there is such an interference.
Been suggested here.
No, absolutely not. But I think in terms of comparators, what we say is that in relation to Article 2 and 3 or an order under the Contempt of Court Act, there is a clear structural basis where, in appropriate circumstances, albeit they may be exceedingly rare, and the circumstances very serious.
I mean, just
They
to be
might be.
clear, Mr. Barnes, the jurisdictional basis of this case is either the parens patriae jurisdiction, which means the jurisdiction of taking care of children effectively in this case. It's either that inherent jurisdiction of the court, or it is Section 6 of the Human Rights Act, which obviously could be engaged, and the court has an obligation under Section 6 of the Human Rights Act to consider convention rights. So those two are, it seems to me anyway, jurisdictional routes that could, in an appropriate case, allow the judge to consider making such an order. Would you agree with that?
Well, we would respectfully submit that as my lord, the Master of Rolls has noted, in this instance, what one is restraining is the simple factual reporting of a judge having sat on a matter or made an order in a matter in the course of their public judicial role, which, as has been repeatedly emphasised, has a particularly important constitutional position within a common law jurisdiction. So what our submission is, fundamentally, that in those circumstances, the content of the potential under Article 8 to restrain is one that, respectfully, does not properly arise in this circumstance. And we would distinguish that from a case that might arise as was the situation in X and Y before Mr. Justice MacDonald, where, for instance,
You have to show us X and Y before Mr. Justice MacDonald if you keep on referring to it, because I'm sure Milady knows all about it, but I may not know all about it.
Yes, I'm obviously happy to take my lord to it. In terms of setting the territory, I think the distinction there is, which I'll develop, is that there was an application being made there on behalf of the Guardian because of specific conduct, targeted, unfair accusations and slurs against the Guardian. One could conceive of a distinction being made between prior restraint preventing the mere factual reporting of a judge having sat on a case against, say, a targeted campaign of unreasonable and unfair, potentially criminal vilification, where I don't say that judges, I suspect to the comfort of the court, on taking up that judicial post, abrogate all rights under Article 8 by any means, and plainly in different contexts it might apply. Where we have a particular difficulty is in the analysis of that as it applies to the factual reporting of having undertaken a hearing in the course of that public appointment.
I mean, you keep on mentioning Article 8, but it seems to me that Article 8 in relation to a judge who is sitting in a public court, whether it's sitting in public or not, but it's a public court provided by the state, performing a public office as a judge. Article 8 is not immediately and obviously engaged. Of course, it might become engaged if evidence was produced, an application was made, or some situation had arisen in which the private life of the judge was in jeopardy. But Article 8, of course, applies to the Guardian and to people who are also performing public roles, but may have applications to make about their private position. But normally, when a judge sits in this position in a court, the last thing on earth anybody thinks about is the private rights of the judge or the private position of the judge. In fact, the whole system is set up so that we perform our public duties quite separate from anything anybody knows or expects to know about us. I mean, in the old days, you knew absolutely nothing about the judge sat on the bench, and they disappeared into obscurity when they went through that door. And you know, that was something that some of us think is not a bad idea even today. So, you know, that. But the point I'm making is Article 8 for a judge is in a slightly, you know, you've got to see how it's engaged if you're going to say it is.
Well, my lord, in terms, I can take it shortly. I agree with my lord.
Well,
we say in the course of that public function, it isn't engaged, and I wonder if it might assist for me to take the court to the Felixstowe justice case, just in terms of setting the territory within the authorities bundle.
Yes.
Mr. Barnes, can I just ask, have you got hard copies available of X and Y with you?
Yes, I'm happy to hand that
It's
up.
just, otherwise I shall...
I apologise, I should, of
otherwise
course.
the danger is I'd have to get my telephone out and message my clerk.
I believe they have been emailed to the court otherwise, but I apologise.
I hadn't
You picking up email?
Yes, I am. Oh, I thought it was.
We've got, I'll forward it to you.
Thank you.
Thank you. I apologise. I should obviously have handed that up when
I mean, just to be clear, Mr. Barnes, I'm not saying Article 8 is not engaged. What I'm saying is that it needs to be explained how it might be. Now, the judge seemed to think it was because the words he used on the 9th of December were media pylon, right? So the relevant thing that he said in his words to the court orally on the 9th of December were media pylon. Anyway, that's my recollection. We can look at it.
Yes.
And so, I mean, it could be said that that is something relevant to an Article 8 right of the... I mean, it could be said. I think that's what's said by some parties before.
Yes. For our part in the submission of the appellant, we find it difficult to see how that does engage Article 8 in the context of what the court was actually restraining, which was factual reporting by media parties of the fact of a judge or judges having sat on a particular matter in some course. And
Of course, on one analysis, the names of the judges were notionally in the public domain up until then, in the sense that if your clients had chosen to publish the name of judges 1, 2, or 3 at any stage before the 9th of December, they would have been entirely within their legal right.
my lord anticipates precisely the background circumstances that I
is
was
that
I was
right?
going to turn to. Yes.
I'm asking you, but
It is. At the point at which the circumstances of Sara Sharif's death came to be reported, there was reporting of the fact of family proceedings having taken place. And at that point, given that orders can be published even under Section 12 of the Administration of Justice Act, unless specifically restrained, at that point, by way of contextual detail, any person could perfectly lawfully have referred to any of the judges. And that, as my lord notes, remains the position up until the point at which Mr. Justice Williams, without notice, indicates that he intends to restrain that publication.
Would the names of the judges, as written down on the orders, have been publicly accessible?
Well, that's a critical distinction that Mr. Tyzack engages with, and we say is something of a red herring. There may be circumstances in which the fact that an order is not in the hands of somebody who is capable of publishing it through the media might act as an inhibiting step.
But we know in this case, because we can see it from the orders and the applications, that Ms. Tickle in particular knew exactly who the judges were. And in fact, there was email correspondence between Judge 3
Yes.
and Ms. Tickle, because she followed the President's guidance by sending an informal email saying, please may I have disclosure from the proceedings that you conducted, Judge.
Well,
And the judge said, actually, I'm transferring that up to the High Court.
yes, in fact, as it transpired, the request was being made to identify who that request should be targeted to, and as it happened, that request came back confirming that was, in fact, the principal judge.
And the
Strait.
judge is named in some of the documents.
Indeed.
I think the C66.
And of course, the court will also be aware that there was release in February of what Mr. Justice Williams categorised as green documents. Those involved position statements and orders. Part of the judge's reasoning for the disclosure of those was his view that had a journalist been in attendance, they would have been entitled potentially to a position statement, and that orders are not captured by the restraints under Section 12 of the Administration of Justice Act. So any media party at the point of the hearing on the 9th of December had access to all of those green documents,
When
which
was
were
the green documents released?
they were not released publicly. They were released to the media parties.
When?
February 2024.
Right.
And at that stage, all of the orders, or almost all of the orders, were included with the names of the judges concerned on them. What is right to say, which may arise in terms of the overall balance of responsibility, irresponsibility, is that notwithstanding that the media parties had access to all of those documents, being conscious, no doubt, of the ongoing criminal proceedings, there was an enormous amount of restraint shown as to the publication of any of that information. But it was all available. Indeed, it's how we're able to make such submissions as we are as to the specific identification of the judges concerned and contextual details. So, insofar as the expression of the broader context, that is an integral part of the submissions I make on the appeal. I wanted to turn, just in that context, the Felixstowe Justice's case, which starts at page 3 of the authorities bundle.
Oh, sorry, I thought you were at X and Y.
Apologies. It was only that there was an interesting distinction within the Felixstowe Justice's case, which I think bears on some of the matters my Lord was raising. So at page 15 of the authorities bundle, 594 of the authority, it notes that a justice of the peace is a known person.
Sorry, you're going to just... this is in Felixstowe.
Felixstowe, yes. Page 15.
594.
594 of Felixstowe, internal page 15 of the authorities bundle.
Yeah, thank you, got it.
Just below E, and obviously this is pre the passage of the Human Rights Act, there's no statutory provision or rule which entitles a justice to anonymity in any circumstance. At G, not been able to ascertain anonymity having been claimed other than by the number of justices. Notably, this applies as much to High Court judges, circuit judges, as to, for example, members of the tribunal. At the very foot of that page, there is an acknowledgement that there may be criticism, vilification, pestering, and so on. And what is notable, in the middle of the following page, 595, 16 of the authorities bundle, talks about some forms of protection against intrusion at B are available. At C, the position is stated that it's inimical to the proper administration of justice and an unwarranted and unlawful obstruction to the right to know who sits in judgment. There is, in my view, no such person known to the law as the anonymous JP. And this is the point that I was driving at. I don't for one moment suggest that the right to know involves the disclosure of any more than the name of a justice. No one can demand the address, still less the telephone number, and so on. So I think there, I respectfully agree that that is the distinction between the naming of a judge and the broader interference with Article 8 rights that might come if there is broader disclosure of any contextual personal details about the particular judge.
There was
but
no
that plainly
internet in 1987,
Of
was
course.
there?
Though no doubt the Yellow Pages or whatever might have produced a similar, albeit more difficult conduit. But I think it's just the distinction drawn there between what the public is entitled to know, the name, and what is protected, namely other contextual identifying personal details.
Yeah.
My lords and my lady, I wanted to address briskly, because I'm aware of the focus of the court's attention on the broader legal question as to the justification of anonymity, with two of the procedural complaints that we have. The failure to give reasons, albeit now in a slightly different context, having the judgment, and the procedural approach of the judge, which we say was unfair and is an aspect that leads the local authority to support in explicit terms the appeal. I then wanted to turn to the new ground B relating to the judge's broader approach to the media, which is addressed in my skeleton argument and in the media party's skeleton at paragraphs 31 to 5 in the core bundle at 119 to 20. I wanted to then turn to the question that has very much been prefaced around the framework for determining judicial anonymity. That may be somewhat more truncated, having had the discussion already. And that was to look both at the principled issues, but also some of the issues around practical workability, which in my submission plainly arise and cause the appellant's particular concern. I wanted then to look at ground D, the specifics of the judge's decision, which we say was wrong, and the overarching conclusion that we say as to the difficulties of endorsing either the approach or the order ultimately taken. And then I wanted briefly to address, as far as it assists, the disposal of the appeal. Though I can probably state that shortly. We would seek for that aspect of the order alone to be set aside, and insofar as the judge contemplates a review process as to the broader terms of that order, we say that should appropriately be...
Can you just help us with a little preview of your last bit of your submissions? What do you say we should actually do if we were to agree with your arguments, bearing in mind the attitude of the judges and some of the other parties and the things that have happened since the 9th of December? So what do you say, taking all that into account, assuming perhaps we did admit the new evidence, what should we do? Do we just lift the order and say, there it goes, or what do we do?
Well, respectfully, our submission is that nothing has ultimately shifted substantially from the point at which we say an unjustifiable order was made. In the course of this process, the court has invited responses from the judges, which was a matter that was within the contemplation of the judge. The limits on their involvement are plain and unlikely to be amended. The paucity of the material, respectfully, in terms of any potential likely harm, in our submission emphasises that the appropriate course for this court is to set aside the order.
I mean, should we give them notice of that and give them time to say what they want about it? I mean, I'm just thinking practically.
Yes. I think in the note, the judges have requested notice of the court's intention, and in the course of the production of a draft judgment, it may be appropriate to notify them as to the outcome and the date on which the court intends to hand down its decision and put in place the order which removes the restraint if the court is with me. And respectfully, we say if that requires a period of a few days or a week to allow proper planning to be engaged, then that is appropriate.
I wouldn't object to that.
I don't think it would be reasonable to do so, given the indication that the judges are all appropriately engaging with those who may assist them in the context of this particular decision. In my submission, though, to take a different course engages the point that I made initially, and this is within the supplementary... no, apologies. It's within the core bundle at 241. This is the note prepared in response to Mr. Justice Williams's invitation to file any written observations after announcing his decision. And over the page at 243, paragraph G, the submission I've made, having summarised some of the jurisprudence that is dealt with now within this court, is the order is unsound. It is also one that, with justification, is likely to raise public suspicion and prove essentially counterproductive. And I would respectfully say that the same...
Reading. G on page 244.
243, apologies. Oh. I think it's tethered to paragraph 2.
Legally unsound, yes.
But I say that the force, respectfully, of of the fact that the order is likely to prove counterproductive in that it raises suspicion, draws attention to the issue, is likely to arise as much in this court, and that the preferable course, on many occasions, albeit it isn't culturally a practice that the family court appears to have adopted with enthusiasm, is that the permitting of reporting is likely to give rise to fewer acute issues of public concern in the way that's arisen here.
Yeah.
I hope that assists. Linked, in terms of disposal, it's probably convenient to deal with that now rather than return to it. I respectfully submit that the removal, deletion of that aspect of the order can take place. There is concern noted on behalf of the local authority and others as to whether this appeal intends to seek to go beyond that challenge. I should say on behalf of my clients, they adopted a position that broadly professionals should be named. They have obviously devoted considerable resource and time to this appeal, including streams of funding for which they are particularly grateful to support it. But given the concerns about the judge's overall approach and his treatment of the media and the appellants specifically, we say that if there is contemplated a broader review of those arrangements with the potential for the local authority or any other party to put a properly constituted evidenced application to support continued anonymity for any professionals, that it should be before a different judge of the division.
Right, but that's not before us at all.
Well,
Only if we send it back.
The question of allocation of the continuing reporting matters may well arise in the event that the court is with me on the concern we raise in the new ground B as to the judge's treatment of the media and the appellants specifically, given that they would be involved in that process, having made that application. We say that goes to an issue of fairness to them.
Well, we'll decide.
Sorry. Are you advertising a future application that the social workers and guardians should no longer receive the protection they have under the order and which is not subject to an appeal?
No. The issue is
Just when you use the word professionals,
The issue is reversed in that the effect of the judge's order was to implement a review of those aspects of the order. I think he anticipated that, along with the review in relation to the judges taking place in March. So that is a procedural.
I think what you're saying, Mr. Barnes, if I understand you correctly, is if we were with you on ground 2B and we thought that he had, to put it in the vernacular, gone over the top about the press, then it might not be appropriate to send it back to him to deal with anything more about it, because he's got a distorted view of the press. But, you know, that's a long way down the road from where we are just now.
Of course.
You've got to make good ground 2B. You've actually got to get permission to appeal ground 2B. And ground 2B may not be, is certainly not the only thing you can say.
Well, my lord, it was merely to set out my end point at a point where the question of disposal.
Your end point is, if that were the case, we should not send it back to the judge.
Yes, because arguably the matters, even if they don't ultimately form part of the appeal, subject to the court's decision, might ground a proper application to recuse in any event.
But I mean, if we didn't agree with him and we said so, then he would know that his view was not to be perpetuated. So judges can compartmentalise their.
They can, though, in a sweeping decision of this sort with the particular issues engaged, that might be particularly.
You might be best
difficult.
to leave that to us.
I'm grateful.
These are sensitive matters.
They are, of course.
But I think we do want to hear why you say that is a freestanding ground of appeal.
Yes, of course. Conscious then that returning to some of the matters of the background, it's only to observe by way of context that the broader decision the judge made was underpinned by the exceptional seriousness and broader public interest of the case. We say that is obviously relevant to the ultimate determination. There were, as the court will no doubt have observed and as has been raised, there were lengthy and complex proceedings arising from the question of disclosure of papers and consequential publication, insofar as that at times appears to suggest a degree of either criticism or concern as to the allocation of resources. Ultimately, the appellants who instruct me are as concerned as anyone as to the over-elaboration of some of these processes, which ultimately mean that the reporting of particularly serious matters where there is a particularly high public interest becomes particularly onerous for them. And that involves obviously time, but also potentially the expense of instructing, as was the case for the BBC, albeit you may have less sympathy with the BBC's overall financial position than those of two freelance journalists. And of course, the devotion of resource is a pressing issue for a number of media organisations. I should say also, by way of background, and I hope it's been foreshadowed, that nothing in the presentation of this case should detract from the appellant's absolute recognition of the particularly distressing circumstances that underpin the application. That is why they consider and pursued the matter in the public interest vigorously from the autumn of 2023, that had important effects, including the publication of information about the wardship proceedings just prior to Christmas 2023, which we say informed the public in a positive way as to the process that was undergoing. And also, they recognise very much the serious incidents that are referred to in the course of the judgment, the entirely unacceptable criminal conduct that can on occasion be directed towards judges. I'll in due course make submissions as to the actual real relevance of that to the particular question, but that recognition on the part of the appellants is absolute. They would note and expect, and again it's a matter that is touched upon in the judgment, that public bodies, including HMCTS, the MOJ and so on, have an absolute obligation to provide a proper framework of protection, and insofar as there are concerns expressed and within the judgment, the release, I'm not sure that was otherwise publicly available, of the fact that in a sweeping way a protocol relating to potentially violent individuals was being disapplied within the family court up until 2023, which is no doubt a matter of concern to the judiciary as much as to those professionals who are engaged in the court, whether lawyers or other professionals. And I by way of aside, the conviction as it related to the designated family judge for East London concerns a case where I was instructed for 2 years to represent the local authority in the course of subsequent proceedings that related to those individuals. And my lady, Lady Justice King, sat in a public appeal in relation to an issue that arose, and Mr. Justice Hayden sat for the entire time as a known judge. So these issues obviously are engaged and are serious. We say they don't necessarily weigh in the balance in this case. And of course, beyond that, we acknowledge that risks can arise in a variety of contexts, and the court may be aware of reporting as to a serious assault on Mr. Sharif in prison himself, which does point to some of the risks, but we say the need for state agencies to properly comply with their obligations to provide protection, rather than that leading to a position where important principles of open justice are infringed or curtailed in a manner that is unprincipled. As I say, I touch on the process simply to note that insofar as the judge is in due course critical of aspects of, he says, irresponsibility on the part of those who instruct me and the broader media, they have sought through a properly constituted application to pursue their applications. They have complied with directions. At times, those have required the preparation of documents to assist the court, even at relatively short notice, the precise the specification as to material that was required, attending hearings and so on. And all of that, we say, it must be balanced against what we acknowledge is the devotion of court resources. In this case, the allocation may have been somewhat skewed by ultimately the ineffectual efforts to return the 5 children from Pakistan. No doubt there would have been more substantive content in terms of the proceedings otherwise. But to set the matter up as suggesting that the media are simply wantonly seeking to draw on the court's resources it is, in our respectful submission, not an appropriate acknowledgement that the practicalities that remain challenging in reporting from family proceedings and the broader ambivalent culture towards the role of the media is very much typified here. And as I say, the media presence, we say, has positively contributed to important reporting in relation to the wardship proceedings, the release of the green documents following a contested issue in February 2024 to ultimately inform reporting post-trial, and of course has ultimately led to the permission to publish the broader sweep of material that has informed important reporting that has flowed from the outcome of the criminal process. I would also say, in terms of the management of resources, and this arises in terms of the practicalities of the hearing on the 9th of December, that ultimately that listing is a matter for the judge. The judge has to ensure proper compliance with his obligations, and the court will have seen the email communication. At the time, there were 2 issues that were being balanced. One was the degree to which the judge was willing or able to make a decision in the absence of a specific verdict, and the other was the resource implications or the time available for when that listing took place. So I hope that assists. Turning then to the framework of restraints, again, this has been to some extent anticipated. The restraint on the naming of children in a manner that is intended or likely to identify them as being subject to ongoing proceedings is considered in Clayton and Clayton, but that is affirmed in Griffiths and Tickle. For the court's reference, that's at Authorities Bundle 300 at paragraph 45. I don't think that's controversial, particularly that once proceedings are concluded, Section 97 no longer acts as a restraint. In the same authority, Griffiths and Tickle, there is attention drawn to the limits of Section 12 of the Administration of Justice Act. The reference for that is 299 to 300. But the most detailed consideration of that issue takes place within the decision of Mr. Justice Mumby, as he then was, in A and Ward. And if the court would be assisted by me taking you to that, in particular, at 161 in the Authorities Bundle, and I should say that in the event that the court wishes it, Section 97 appears at page 411 and Section 12 appears at 409. Obviously, Section 12 provides that proceedings brought under the Children Act or the Adoption of Children Act or in the exercise of the inherent jurisdiction are private. Subsection 2, this is on page 409, provides for the publication of the text or summary of the whole or part of an order. And subsection 3, as is noted, specifically refers to references to a judge and to a tribunal.
So where are you reading now?
It's 409 is simply the framework of section
409 of what?
in the Authorities Bundle.
Oh, I'm sorry, I thought you were on 161.
Apologies.
Section 12.
Sorry? Yes.
Section 12. Okay.
So yes, subsection 1 makes provision for those hearings to proceed in private. Subsection 2 specifically makes plain that the publication of the whole or part or summary of an order is not a contempt. unless there's an express prohibition on publication. And then in this section, references to a judge, to a tribunal, include any person exercising the functions of a court, judge, tribunal. So that is the statutory framework that then is considered by, I think, then Lord Justice Mumby.
The exclusion comes through subsection 2 and subsection 3 read together, because it says that the text or summary of the whole or part of an order made by a court, brackets including a judge,
Yes.
shall not be a contempt.
Yes.
Yeah.
And necessarily any order would include the name of the judge
Yeah.
or judge
Yeah,
making
I
that order. For the avoidance of doubt, that also probably makes plain what is in any event the case, that the restriction, and this is considered by in the Ward case, is as to information relating to the proceedings. So the degree to which the judge who was sitting in a publicly published list, albeit in private, that we respectfully submit is not information relating to the proceedings. But I'll turn to Ward for that purpose, because at 161 in the authorities bundle, page 1520 of the particular report,
Yep.
the court there was considering the effect of section 12 and the restraint that involves, was quoting from an earlier decision at paragraph Roman numeral V, sets out matters that the section doesn't prohibit the publication of, and this is the distinction between information relating to proceedings and matters that are not captured by that phrase, which includes the fact that a child is subject to proceedings, or indeed the nature of the dispute, things that have been seen or heard by a person conducting himself lawfully in the public corridor. That would, of course, include reading a published list. And, of course, Roman numeral V, subparagraph I, the text or summary of the whole or part of an order. And so it also sets out what is prohibited, which is principally accounts of what has happened, and documents, at the very foot of the page, documents prepared for the purposes of the proceedings, and then over the page, I think that might include position statements, skeleton arguments, and so on. And of course, that is a restriction that is addressed in the course of the transparency pilot by making an order which permits the disclosure of certain documentation to media representatives who are in attendance. I don't understand that any issue is taken as to the delineation, but I think it helps to set some of the territory for the broader submissions that I make. And then further on at page 170 electronically or in hard copy of the authorities bundle at 1529, there is a helpful consideration of again what the boundary is as to what information relating to the proceedings actually captures or doesn't. And there are various examples, but birth certificates or minutes of conferences that take place away from the proceedings that are simply filed within the proceedings, the delineation suggests don't get captured. And again, in those circumstances, this serves to emphasise that whilst the statutory restraints may have the practical effect of inhibiting the actual possibility of reporting or publishing matters pertaining to proceedings, if that by a side wind means that a judge or particular information that would otherwise be reportable is not in fact reported, doesn't suggest that those restraints are targeted or justify a particular explicit restraint as to, say, the name of a judge. And if at 113 it is the case that it's it's not a breach of Section 12 to publish a fact about a child, even if that fact is contained in documents filed in the proceedings. We struggle to see how Section 12 then meaningfully bears to create any point of distinction as between proceedings in the family court or the family division of the High Court as to the naming of a judge in comparison to any other court. And that addresses the final point of that background context that I had indicated, which is that even if Section 97, while proceedings are ongoing, or Section 12, even after they have concluded, creates a specific, defined, justifiable, according to the parliamentary decision-making, incursion as to the broader application of open justice principles to that specific aspect of the work of the family court. What it doesn't, in the appellant's respectful submission, is create a parallel process of what the judge coined, I think, for the first time, of shielded justice cases, where some different principles might be said to apply to matters that even those matters not captured by the statutory restraints. We say that is a very troubling position for the judge to have arrived at, to essentially seek to create, for the first time, a parallel delineation where the ordinary writ and law doesn't apply. We say that flies in the face.
So can you just show us where you say he did that?
Yes, of course.
So we've got his judgment, or I've got it separately. But,
Yes, the judgment is at 62 in the core bundle.
which paragraph are you going to?
So at page 87 of the core bundle, paragraph 61,
Sorry, which judgment are you in the June judgment or the...
no, the most recent judgment, it's page 87 in the core bundle. Paragraph 61 is the conclusion. Where the judge is reaching conclusions on the naming of third parties and judiciary that relates to presumptions, he says, don't apply in, quote, shielded justice cases.
I think that terminology starts within this judgment.
It does.
Paragraph 27, which refers back to the June judgment.
Well,
It made no reference to judges.
well,
And I don't think it made reference to shielded justice either.
it's broader than that. The June judgment that is referred to, A, makes no reference to judges, but B, makes no reference to this parallel shielded justice
yes.
structure.
Good, well, we agree.
So insofar as there is a critique that the appellants should have addressed the structure and framework of the law that was set out by Mr. Justice Williams in the June judgment, it would be difficult to challenge or address a parallel shielded justice process that arises for the first time in a December judgment that post-dates the decision. Of course, the June judgment considered the statutory framework and the open justice principle, but I'm confident that the first occasion on which the definition shielded justice...
Well, he uses the term shielded twice in his June judgment. He uses it at paragraph 78.2, but not shielded justice, just shielded. Uses the word 78.2 and 93, but in neither case does he uses it as shielding people from further exposure, but nothing to do with shielded justice. That first appears, I think, as my lord said, in 28, is it, of the second judgment?
Yes, well, it's page 75 of the core bundle is paragraph 27.
Yeah.
And yes, there has, it appears, been something of an evolution in the judge's thinking that insofar as the statutory provisions restraining the publication of certain informations may be a shield as to information, though we would question, given that they plainly don't shield the naming of a professional on anything other than a side wind.
But you say, I mean, to put it bluntly, you say that sentence that says, in that judgment, I identified that the historic proceedings occurred in the shielded justice environment of the family court, not the open justice environment of the criminal and civil courts, and that environment was created by statute which displaced the open justice principles, is, if not completely wrong, is distorted, because there is no different principles applicable. The open justice principles are applicable, subject to the statute that Parliament has imposed to restrict them in particular cases.
Yes, and insofar as
In
the
what?
Court of Appeal, insofar as the Court of Appeal in Griffiths and Tickle
Yeah.
emphasised merely summarising the broader case law, that what is created by the statutory provisions is a narrow, specific exception to the open justice framework, save where those exceptions apply, it is without any precedent for the judge to say that there is a broader disapplication or abrogation of the open justice principle in
Doesn't
family court.
quite say that, but I see what you mean.
And we would say that in fact the contrary position might pertain, which is that in the case of the family court, where there are matters that are subject to the statutory provisions being restrained, it might well emphasise as a concomitant that insofar as matters fall to be considered in the broader sweep of the open justice principle, and bearing in mind the conclusions which again have been reinforced by the senior courts as to the importance of transparency for the family court, that derogations from the application of open justice to those matters that aren't subject to statutory exemption, by view of some misunderstanding or distortion as to the application of those exemptions, is a particular concern.
Yeah. Well, you say there's no such principle. The principle is the open justice principle, and that's to be read subject to statutory restrictions,
Yes.
which are Section 12 and Section 97, and that's it. And if they don't apply, nothing else does.
And so,
Good.
with the absolute respect to my lady's formulation of the case, because obviously these matters arise within family proceedings, we say the question for the court is, what justifies the anonymity for a judge simpliciter? It isn't
We're
bound.
all responsible for my lady's formulation.
No, of course. And
My shoulders are broad.
I entirely accept these proceedings arise from family proceedings, and I don't take issue with that. It's simply for the purpose of this presentation. What I seek to emphasise is
we
that,
get
in fact,
No doubt the the person appointed on behalf of the Attorney General would have liked to have spent even more of his weekend doing a comparator with
No, I've no doubt.
non-family proceedings.
We all accept, and we're anxious that the late participation may delay matters. So we are particularly grateful for Mr. Tyzack for the way in which he has put matters before the court and assisted.
Yeah.
On the other hand, I suppose addressing the relevance of family proceedings or the family court, what the appellants would recognise is that it is striking that this is an order, an unprecedented order, that arises from the family court, and that insofar as there have been other examples of a difficult engagement at times between the family court generally, or even specific judges within the family court, it is striking that this particularly exceptional order, unprecedented order in the context of what the judge did, in a situation where there was no procedural compliance, does arise in family proceedings, and that without wishing to be unduly critical of a broader system of which I am a part, does reflect a continuing imperative to drive proper cultural change as to the role and place of the media in undertaking the important functions that have been cited in Griffiths and Tickle arising from the President's decision to implement the
I
transparency.
mean, whilst I fully understand your submissions about cultural change, we generally confine ourselves to deciding legal issues in this.
Of course. But I suppose what assists here is the intersection in this court between members of this court's constitution of different backgrounds, considering how this order arose within the context of family proceedings, and in our submission, proper compliance with procedural requirements, proper application of broad principles, a proper understanding of the open justice principle and the role of the media are all critical and fall within the contours of my Lord's decision.
So far as I'm concerned, Mr. Barnes, you will be pushing at an open door if you say and submit that family law is not another country, it is just part of our law.
Well, and on that, I hope my Lord is aware that that is part of my broader submission. I cite the case of Preston Petronell for the purposes which I suspect my lady will be particularly familiar with, and the broader context that the family courts are not a legal Alsatia, I think, is the other term.
But I mean, the question here is a simple legal question. First question is, what is the effect of Section 12? Actually, it's not Section 97. So what is the effect of Section 12?
And we say
the
none.
second question is, under what authority could the judge have done what he did? And if there is such authority, did he correctly exercise it?
Yes.
And of course, there's the procedural question on which you're placing a lot of emphasis, but ultimately, we're here now. And you can complain like Billy O that the procedure was wrong, but if the law was wrong, that's enough for you.
Indeed, though, in terms of, well, I'll address, as I say, briskly, the initial procedural issues and then move on to what I entirely understand is...
Well, I mean, you say he should have given you a chance to make submissions before he said what he was going to do.
And that it was entirely unacceptable on the basis of what I think, again, is uncontroversial principles, that having made this particularly exceptional order, there were no reasons even provided by the 13th of December.
Okay, yeah, we get that.
And you have my submission in the course of the combination of the permission to appeal skeleton and this as to the failure to give reasons. But undoubtedly, even if it seems surprising, the judge was not contemplating that the order might be controversial until the point he announced the decision. Once he was aware of the controversy, it behoved him to respond properly and appropriately to an issue that was both controversial and unprecedented in my submission.
Can I just ask this in relation to procedure? There seems to be a measure of disagreement in this court about whether this was an interim or a final order. On one analysis, it's a final order with an opportunity for review. I think on the father's analysis, it's an interim order.
Yes.
It might make a difference to the right approach
Yes.
of a court. It might make a difference, if it matters, to the procedural complaints you make. I mean, if it was a trial and the decision was made without notice that it was going to be made, without an opportunity to make submissions, that would be a more extreme version.
I think the difficulty with it...
Scenario you paint.
The difficulty with it being treated as an interim order is that the effect of the order on the analysis that is responded is the respondent's analysis is that once the order is made, is there then an obligation for the court in discharging that order to take a different approach or apply a particular balance that might be said to arise? And of course, the order was not time limited. It was a capacity to review once matters had progressed.
Well, it was limited to 2040. I think it lasts until 2040.
Yes. Insofar as the protections in relation to the children conventionally are bounded until the youngest child turns 18.
Yes.
That was the basis of the judge's order. And in the course of the permission skeleton, yes, in terms of the impact and effect of that order, in the permission skeleton at Core Bundle 203, paragraph 23, I quote the decision of the Strasbourg Court in Observer and Guardian, that the dangers inherent in prior restraints as such they call for the most careful scrutiny on the part of the court, especially so as far as the press is concerned, for news is a perishable commodity. To delay publication, even for a short period, may well deprive of it of all value and interest. And in this case, the critical nesting of this order falls as a striking emphasis of that.
There's nothing we can do about that now because the order has been in place at the critical time for the reporting of these matters.
And for the avoidance of doubt, those who instruct me are extremely grateful to the court for the steps that were taken on an expedited basis, both to seek the provision of the judgment, which would otherwise may have been published in or around or somewhat later than now, and the steps that were taken to list this appeal urgently. We accept entirely this court has done the best that it absolutely can. But what is important to note is that insofar as the judge made the indication on the 9th, maybe he was justified in extending that protection until the point of review. I mean, you know, that was the point at which he was able to consider the written submissions. But as at Friday, I think fatefully, probably Friday the 13th, I think, of December, that is nestled between a conviction, the conviction being announced and the sentencing that is due to follow, I think, on the Tuesday or the Wednesday the following week. So the idea that at that point, 3 months is neither here nor there, even if it is considered an interim decision, is an exceptionally problematic position to arrive at, and we say doesn't accurately reflect the importance of the currency of that information, the devotion of resources at that time-critical period, and the degree to which the striking inability to identify who had sat on the family proceedings was glaring at the time that the issues around sentencing, the role of the family court, first then came to the public attention.
So the 9th of December is before the conviction.
Yes,
The conviction was on which day?
I believe it was the 11th,
On the 11th.
the Wednesday.
And
And that was why there was the imperative then for the judge to produce the order which he produced on the evening of the 11th.
and
the-
sentencing?
The sentencing,
17th.
the 17th. So the review decision, again without reasons, is announced on the close of business Friday the 13th. The appellants lodged their appeal with this court on Monday the 16th. The sentencing happened on the 17th in the morning, and obviously those are, as has been noted, publicly available and were streamed live, again, consistent with the overwhelming public interest in the case. So the combination, we say, of the procedural unfairness, of the fact that, as my learned friend on behalf of the local authority observes, not just some, but the vast run of the judge's reasoning, exposition, and so on, was simply not known to any party, and couldn't be addressed or responded to, amounts to an exceptionally serious procedural error, and one that in our submission grounds the appeal being permitted on those procedural bases. The reality is that, as is highlighted in the case law that I rely on in the skeleton, the obligation to give reasons arises in a context-specific manner. And in this case, the judge was making an exceptionally unusual order against the entirety of the UK media, in effect, and without notice and without reason. And that, in any division, in my submission, amounts to a serious procedural irregularity, and one that goes to the lack of reasons and the process adopted, on both of which I say the media should succeed. And in a sense, the zenith is the judge's creation or description of a parallel jurisdiction in which shielded justice principles as opposed to open justice principles apply without notice to anyone. And it may be that it's a warning that on occasion inviting submission is a better way to arrive at a coherent, properly legally grounded order than to proceed alone.
That rather founds our justice system, Mr. Barnes. We
One-
like to hear both sides of the argument before deciding.
But one would think, albeit this judgment may stand as a strikingly dissonant note within that, especially when at paragraph 60, and this
60.
concerns the approach to the media. This is at page 86 of the core bundle. So I've dealt, I hope, suitably briskly with the procedural matters that I hope are not necessarily troubling to the court.
You're at paragraph 60.
Paragraph 60 in the core bundle at page 86 of the December judgment.
Yes.
About 7 lines down, given my Lord's observation, it's notable that given the deficiencies of the process adopted by the judge, it sat somewhat uneasily to suggest that, that thank goodness journalists don't have to operate as the courts do and hear both sides before delivering their verdict. I mean, there could be no more striking juxtaposition than to deal out that particular critique in this particular moment and with this particular process. I touched then the additional ground that with Commissioner Milady we were permitted to amend to include. What I have sought to emphasise is that the deficiencies in the judge's overall the fairness of the judge's overall approach to the media was, it would appear, a general one, albeit it found a particularly prominent tenor as it was directed against my clients, the appellants, specifically. It is, of course, right to observe that insofar as it forms part of the judge's reasons, insofar as there may be one marginal criticism on which this question of misreporting arises, we say it was grossly overinflated by the judge and necessarily cannot have formed part of his consideration on either the initial decision or the review. So at that point, what place does that have within the judgment? And what plainly arises from paragraph 59, where, on page 85, where the court is invited to proceed on the basis that reporting will be responsible, fair and accurate. That is less an invitation to a judge to ignore reality, but a proper application of the limitations of the role of the judiciary as public servants in critiquing, in analysing lawful aspects of media coverage, and certainly doesn't invite a judge to pick favourites, engage in unwarranted and critique and criticism without notice, or to more broadly seek, as happens in paragraph 60, to seek to draw some link between those who I represent and those who were convicted of criminal conduct giving rise to the Leveson inquiry. It is an unacceptable, unwarranted approach. It is based on a gross exaggeration of a marginal issue which at its highest amounts to a modest misreporting, if at all, which was appropriately clarified through the appropriate editorial process that is the province of the respective news organisations concerned. But the judge refers at the bottom of paragraph 59, this is on page 86, to critiquing reporting of murders. He doesn't give precise examples about, but seems to suggest that there is some concern about the reporting. He then goes on to the way in which those with malign intent can rapidly distort information. He then gives an extract which we understand to be part of one of his historical judgments, critiquing a headline which, beyond the fact that the judge fails to read it with the broader piece, which I think my learned friend raises doesn't appear to be any sort of glaring misreport and doesn't appear to have any particular relevance here. He then takes a sideswipe in paragraph 60 to a dispatches programme broadcast on the 20th of July, where he says, rather luridly, I could make several observations. He then goes on...
Is your fundamental criticism that he is... two things, really. I mean, he's justifying a previous decision by reference to things that are nothing to do with the case.
Yes?
And the things that are nothing to do with the case are not in evidence before him.
And
Taking, I mean, you might say judicial notice of, look, we know lots of things as judges, but normally if we're going to rely on those lots of things, we say to counsel in court, I know X. Would it be justifiable for me to take X into account in deciding this case? And counsel will say yes, no, or maybe.
these relate to core principles of judicial restraint,
Yeah.
of judicial fortitude, as opposed to a rather thin-skinned and prickly approach to relaying...
A fragile approach.
Fragile. I'm entirely content. But it's striking that where in the Harris decision that the court has, Mr. Justice Mumby, rightly we submit, notes that those who apply and sit within the judicial role, by definition, have put themselves in that position because they consider and bear themselves with the dignity and restraint that goes along with that role.
So what's the reference to that?
Yes, that's within the authorities bundle.
This is called Harris, is it?
Yep.
Harris starts, it is a lengthy judgment, at page 20. But the particular reference is at page 65 in the authorities bundle.
Yeah.
So paragraph 64, I think, sorry, page 64, paragraph 368, might also help while we're with the authority in setting the context.
Sorry, where are you? 368.
Paragraph 368, it's internal
Freedom to
page...
publish things which judges might think should not be said, should not be published, is all the more important. Yeah.
Yes, and of course, in this case, part of the rationale for the judge restraining the name of judges was that he felt that the media should be reporting on broader systemic pressures, and so he wasn't going to give them the material to individualise as opposed to systemise their reporting. And that talks at 368 of even more cogent must be the justification for the power of prior restraint. But it's over the page at paragraph 372. It's not the fundamental thesis being advanced in the Harris case is that the role of the court is about the enforcement of its orders. Is there a contempt? Is there not a contempt of some restraint on reporting? It isn't to engage in a broader critique of whether it likes or dislikes or feels that reporting could be more or less perfect or akin to its own particular views. And rather than the obligation to treat media parties as fair, responsible and accurate, being, because that is in every circumstance the actuality of it, what it reflects is the weight that is placed on freedom of expression and the way in which the media goes about its legitimate business under those protections. In the middle of paragraph 372, what is said in Harris is that judges, after all, are expected to be, and I have no doubt are, men and women of fortitude, able to thrive in a hardy climate, and the vehemence of language used cannot of itself measure the power to punish for contempt. On the contrary, so long as it doesn't undermine what in 10.2 is referred to as the authority and impartiality of the judiciary, such criticism is healthy.
But looking at the bottom of that paragraph, where it starts, much of what might well, even in comparative reasons apart, seems to me to be recognised as amounting to no more than acceptable or trenchant criticism. Now, this is a 2001 judgment, so I think we have to read this, do we not, in the light of the increase in social media and the approach that we see in social media, which it might be thought on occasion, certainly so far as the father is concerned with his application to adduce fresh evidence, goes considerably further than amounting to more than acceptable trenchant criticism.
But of course, what there needs to be delineated is between the reporting undertaken by the media and other matters that may follow that actually aren't the province of the media, and that's the delineation that is also emphasised in the Saka decision in terms of the concomitant tale. It isn't about that the media are going to be directly threatening a judge with physical violence. If there are loose, unpleasant criticisms and threats that are raised within largely the anonymous confines of social media, how far that impacts on the ability of the court to restrain the media from reporting factually, I think is the problem that I emphasise. But in this, it is that striking juxtaposition between what is here, what must apply with even more force, that of course the context in which judges are sitting has developed as social media has developed, but equally the processes and insight into that might be said to have developed, and the degree to which advice is given to judges as to their engagement with social media and so on is obviously...
But why should the judge, why should the judge not take into account the progression Milady is talking about, the fact that there is now what he called social media pile-on? I'm not quite sure I really understand what that's supposed to mean, but I think it's supposed to mean a lot of very hostile threats against judges. Surely, if that were the case, and we know that adverse incidents have occurred recently, would that be something of which he's entitled to take judicial notice? Or would you say that it's just nothing to do with anything?
Well, I don't obviously set myself Canute-like against the developing tide of social media and its potential impact. But I wonder in that context whether...
Just assume that he had known that there was social media coverage of the kind that they've put in. And I know what you say about it. You say that it doesn't really amount to all that much. But let's assume there was a genuine threat made on social media about the judge, and he knew that. Would he have been entitled to take that into account?
Well, it depends on whether it arrives at the position where Article 2 or 3 is engaged.
Yeah.
And so
procedurally, he should have asked for argument on that. You say evidentially he shouldn't have relied on evidence without asking the parties what they thought about it. And so even if he was entitled to in a case in theory, here he shouldn't have done.
Yes,
but you can understand, can't you, in a very fast-moving case, fast-moving situation like this, where he's been forced to do it at short notice for half a day when he wanted 2 days.
Well, I think he did retain some of that time for his preparation.
Yeah, anyway, he was in a rush. Everybody was in a rush because the criminal trial was moving apace and coming to its conclusion. He knows the sort of general landscape, which is the direction of travel is, as my lady suggests, over the last 25 years. And is he obliged, this is what I'm asking, completely to exclude that from his thinking, leaving aside the procedure for a moment, or is he entitled to say in his putative judgment, which he doesn't give until much later, and you say he should have given earlier, but let's leave all that aside, is he entitled to say at that point, on the 9th of December, I have taken into account the rising tide of adverse, hostile social media coverage, etc., and I'm taking that into account, query under Article 8, but possibly under Article 2. I mean, he would be entitled to do that in theory, wouldn't he?
Well, I say if there is established case law with which the judge does not engage that relates to the need for coherent and cogent evidence to substantiate an Article 2(3) risk.
Sorry, I didn't hear that.
There are requirements to produce cogent evidence to substantiate that the Article 2 or Article 3 is engaged in the event. And so there is a broader concern that taking judicial notice of a broad potential for pile-on is not in any world going to surmount that hurdle. What I would say is that the way that the judge is obliged to approach taking appropriate judicial notice, if it is to be factored in, of the impact of social media has to be engaged with in a judicious and temperate fashion. And actually, as it happens, the judge's approach is one that descends into what we say is wholly unjustified alarmism. The approach of Mr. Justice Nicklin, and this is in the authorities bundle, starts at 269. This is the various claimants and IPSA case. Comes down to it comes to its conclusion at page 286. It's paragraph 52. It's internal 163.
Sorry, paragraph?
52.
Thank you.
Which page? 286?
286 of the authorities bundle.
52.
And, curiously, my namesake makes a frank recognition, but what is striking is that in this case, those who were pursuing the claim sought to put a proper application in for anonymity, grounded on, in part, threats that might arise in the course of that information being made public. But what is said here, and what we respectfully submit applies with equal force here, is, of course, it would be ludicrous to say that there aren't a small number of people who may take extreme action at times, and they might conceivably move to offer some threat of physical violence. But at 52, that risk is remote. And undoubtedly, that applies when you're talking about general media coverage of a judge's participation. And that's where we respectfully distinguish it strongly from the very serious criminal conduct that the judge refers to in relation to at least 3 sitting family judges, albeit one of those, it arose as a consequence of sitting within the tribunal. On each of those occasions, though the course of criminal conduct that arose was from a litigant who had appeared before that judge. And insofar as there might be a person prone to taking unjustifiable criminal action, the degree to which they're engaged, if they are the person who is appearing, is, in my submission, a quantifiably different situation.
Put this to you, because, I mean, I take all those points, and the comparisons are nearly always invidious, and these ones look pretty invidious. But I'm pretty concerned with the legal position. I know that's, call me an old judge if you like, Mr. Barnes. I am very concerned with the legal position with which the judge was faced on the 9th of December. And I think what you're saying, but correct me if I'm wrong, is that the procedural complaints that you make feed in to the jurisdictional position because they actually mean that it was improper for him to start any balancing exercise under, say, Article 8.
If that is the framework.
Article 8 or Article 2 and 3 on behalf of the judges without calling for evidence on the subject properly documented, and it was simply wrong to take into account or take judicial notice, as we sometimes say, of matters that may disclose a direction of travel, maybe a direction of travel that we might regret. But nonetheless, that's not good enough to engage as a jurisdictional matter, Article 2, Article 3, Article 8, on behalf of judges sitting in the way judges sit. We've discussed that already. And had he wanted to undertake the balancing exercise that Re-S envisages at all, or take into account Article 2 threats on behalf of the judges, he had, as a matter of procedure, to seek evidence and submissions. It was simply not possible to engage in a vacuum those articles as a matter of jurisdiction. That's not what Section 6 required him to do.
And we would go further.
It's your submission, I think.
Yeah. And we would go further to say that the position that this court arrives at, somewhat later, and with a greater degree of circumspection, having encouraged and invited participation, is that evidentially one is, in a sense, the paucity of that evidence and the lack of justification for even engaging in the balancing exercise is crystallised.
Yeah, but I'm sorry to hold your nose to the fire of jurisdiction, but it does seem to me that a watershed is reached in this case at the point on the 9th of December when there has been arguments about the way in which the reporting restrictions should be lifted, and it comes into the judge's mind at 4 o'clock or whatever it is that he should include the judges in his order to apply protection to them that Section 12 does not apply. And at that point, the question that arises to me anyway is, does he have jurisdiction to do that at that point on the 9th of December? Now, the answer to that question is he may do if Section 12 allows him to do it, but I think it's agreed by all parties that it doesn't. And so the only thing that might allow him to do it would be the CPR, which in civil proceedings would allow him to do it. Section CPR Part 39 to whatever would allow him to do it in civil proceedings, but not in family, not applicable to family proceedings. And so the only two things that could are the parens patriae jurisdiction to protect children, these children, living children, or Section 6. And your submission is neither of those was at that moment engaged, so he did not have jurisdiction.
Yes.
And that's a matter of law.
Yeah.
And if you're right, I don't know if you're right or wrong, but it seems to me that is the relevant point. And no amount of ex post facto justification can mean that he was right at that point.
Yes, I suppose that the ex post facto justification might go to the coherence of the decision on the 9th and inform it in that reflective way. But there is a particular difficulty as well, that, and it's a point that the judges make in their note, is that this order is foisted upon us without notice even to them. And I understand and respect the position that some are now in, as expressed in that note, of being desirous of protection. That's an understandable broad statement of wanting it. What they don't do is assert a positive case that is justified, albeit there would be nothing that would deny them or some other agency on their behalf making a properly constituted application if there was sufficient risk to give rise to it. But there is a particular difficulty in the judge's rather freewheeling procedural approach, in that he didn't ask himself those questions. He didn't ask himself how far that application was probably before him, or whether he had a want of jurisdiction at the time, and that relates to the broader procedural issues that we raise as well.
But I mean, the criticisms of his judgment are all really ex post facto. I'm sorry to use Latin. I criticise everybody who does, myself. But the criticisms of his judgment are all really after the event.
Yeah.
And, okay, you say he attacks the media and that's over the top and inappropriate and et cetera, and I get all those submissions. But if he didn't have jurisdiction to do what he did on the 9th of December, that's all nothing much to the point.
Well, I don't know, because the court is capable of disaggregating between the different complaints that arise, and each have a potentially important component in terms of the framework that this court sets out for any equivalent judge where it might equally pop into their head.
That's what I wanted to ask you, really, because these cases don't arise very frequently, and I've already said this raises important matters of public interest. And so let us postulate a similar situation arising tomorrow where the judge does know of a threat against the judge. However, it doesn't really matter how serious, but there is a real concrete threat. What then is the judge to do?
Well, I suppose expanding out matters, saying this doesn't apply just to family proceedings, equally we are but one constituent nation of the broader state, and there's a particularly prominent example in the jurisdiction of Northern Ireland, where specific issues of risk arise. The starting point is properly engaging with the institutional architecture of ameliorating and addressing those risks. And so I would respectfully suggest that in any case where a judge develops a concern personally, or where there is a particularly egregious issue, then it may well behoove that judge to engage with the institutional architecture that is available.
But the institutional architecture doesn't really help him, because he can't, in the moment, ask what the judges think. It's not practical and not appropriate.
No, but for example, in the Marsden case, where a legal issue arose for Mr. Justice Leven as to publication, which would mean that magistrates could be named and a legal advisor could be named, Mrs. Justice Leven took the approach that was open to her of inviting submissions from HMCTS as to the status of the legal advisor in the context of those proceedings, whether they were undertaking a judicial function, and that is a route whereby, as the note indicates, the judges have engaged entirely appropriately with such protective framework as I'm aware of, and it may be that the court is more aware of some of the underpinning that is available to identify and/or address.
The answer to my question is either the judge should think the matter is not sufficiently important to take further, which must be most often the case.
Well, I think almost always, but yes, I agree.
But no, because we don't know what may arise in the future. If the matter is really very serious and very concerning, and there is evidence of it, then he is obliged to seek submissions from the parties before him and from an authority acting on behalf of the judges, if not the judges themselves, you would say.
I would have to bow to the force that the public authorities in this country cannot permit a credible, serious risk under Article 2 or 3 to be unaddressed. Now, whether I think there has been some debate in the constitution of this court as to the degree to which once that is engaged, one undertakes a balancing exercise. And of course, we would say that the first port of call is for those organisations to take appropriate steps to address the risk in a way that doesn't require an infringement of open justice.
Judges do not have a cause of action, do they? So in other situations, parties may have a cause of action for breach of privacy or some other cause of action. But judges wouldn't have a cause of action themselves to protect their privacy. I don't think. I mean, I'm asking.
I don't know. I mean, obviously, judges have brought various courses of action. There was high-profile litigation in relation to judicial pensions. I don't. But their ability.
I think my lord is
in this
picking up on a point that we've debated and originated with me. In the factual scenario we're considering here, where the perceived risk is of in unacceptable interference with private and family life rights resulting from publication, not so much media publication, but on social media, involving matters that may even threaten physical well-being. The question is, would any judge in such a situation have a private law right of action to seek an injunction in their own right? And it seems to me it's quite difficult to find a cause of action in breach of confidence, misuse of private information. The only possible cause of action, and one that has been deployed on at least one occasion, is harassment.
Yeah.
But this might be part of the legal analysis, that one may be forced back on the obligation of a public authority under Section 6 of the Human Rights Act to protect convention rights where that is necessary and proportionate and the only effective method, or the least intrusive method, because there's nothing else.
I think the effect of the position in this instance is one which points to the sharper delineations in that. What I in my submission is difficult is to ground a prior restraint application on an Article 8 basis, particularly where the information being conveyed is simply the fact of a judge's participation in the course of their public office. And that may be distinct from such cause of action as might arise where there is the positive obligation that arises under Article 2 and 3, which isn't on all fours with the structural position under Article 8. Also, this court is considering the question of prior restraint in the context of such evidence as there is. As I say, we would submit that has to be addressed in a temperate manner that is accurately conveying that whilst threats can be made that are unpleasant, there is, in reality, limited practical follow-through where those threats are generic, not specific, and based on social media, and that might distinguish a specific cause of action arising from harassment if somebody, and critically, there is a distinction to be drawn around the fact that if someone is making demonstrably untrue claims to vilify and harass, then that might engage those issues differently than the reporting of the performance of that public function. So that's where I sought, and obviously I hope it has assisted to set out the territory where we accepted that there were areas where we could see that if Article 2 and 3 is engaged, that might give rise to an issue, where the jurisdiction under Section 4.2 of the Contempt of Court Act might give rise to concerns about the administration of justice. That might be an issue. None of those appear to apply. And when one is faced with the situation as it appears before the judge, we say it is very difficult to see how Article 8 bears on this decision. And in those circumstances, given that the judge, even on his own conclusion, doesn't engage Article 2 and 3,
I mean, Article 8 is a surprising thing to try and engage on behalf of a judge when you have no knowledge about the judge's private circumstances, because it's a right to private family life. How are we saying the right to private family life, or how is it said the right to family life of a judge who is unknown, personal circumstances are completely unknown, are infringed by potential criticism or potential naming, the naming being of the fact that they sat in court and decided a case some years ago and made an order as judges do every day. So that's why I find Article 8 difficult to address. But Article 1 to Article 2 and 3, of course, I find much easier to, because if there were risks, the court would want to be astute to address them and would not want to be hidebound by waiting until harassment or violence had occurred and say, answer the rather more difficult question, does the judge have a case in harassment or a case for breach of infringement of privacy, or does the judge have a case for breach of confidence? I mean, all that is way down the track. So one can see the judge's desire to address the question, but there has to be a jurisdictional foundation to address it. And I see it as a sort of can, a box, if you like, that you have to open the box. You have to have a reason to open the box before you consider the question. And that's partly because, and it's something else I wanted to put to you, of the extreme consequences of opening the box. Once you open the box, you've got to have evidence, you've got to have submissions, you've got to have courts, you've got to have appeals. It could take ages. Meanwhile, of course, the press can't report what you say is a perishable news item.
And my lord anticipates, I think, almost entirely comprehensively, the practical matters that I was going to raise as to the complexity that it gives rise to if the box is opened. And of course, the difficulty here is that the judge is seeking to suggest that even within his parallel shielded justice framework, an order anonymising a judge would be exceptional, albeit because he's reliant on a generic position. Who wouldn't it apply to? Every judge in the family court makes their decisions, or might be published, in the context of known attacks that he's listed, and no doubt those that he hasn't, and the context of the broader landscape of social media. Now, there might be said to be some variability as to the particular importance of a particular case and the degree to which it generates interest, but it's hard to conceive of how one builds in then structured limitations. If this judge's approach is appropriate in this case, what is the confines of that jurisdiction? And this goes to the very heart of the point that I've made on behalf of the appellants, that part of the process of seeking to provide a means of increasing transparency in the family court has been to seek to reduce some of the barriers to entry. But if one has to create an elaborate architecture to deal on a potentially regular basis with imposing the need to undertake Article 810 balances on a whole constituency of judges, of whom, sadly, the lack of judicial continuity might suggest that there would be many, to take that into account in making these decisions, it gets to the point of being completely unworkable. And it is in direct contrast to a properly formulated, constituted risk assessment or evidential foundation for engaging with an Article 2 or Article 3 risk in a particular circumstance, which would no doubt need to be justified, potentially tested. You might have to hear submissions on. But the expanse of that additional jurisdiction in those very rare circumstances, and it's right to say that theoretical jurisdiction under Article 2 and 3 to protect a judge has presumably been in place since the Human Rights Act came into force, and has not been, to the knowledge of those before the court, deployed, even in the striking context of the jurisdiction in Northern Ireland. So, respectfully,
okay.
my Lord encounters the territory which I address in the skeleton argument. It is a point of clear departure, because even in support of the appeal, the local authority suggests that Article 8 starts with the word everyone, and so the Article 810 balance must be the framework. There's no suggestion there's a different one, and I think the same point is taken by the advocate to the court, and possibly on behalf of Mr. Sharif as well. But we struggle with the legal and intellectual architecture that permits of that reliance on Article 8 in the context of judges. And as I say, that isn't to say that in all contexts, judges abrogate all Article 8 rights at all on taking office. Plainly, they don't. But in the context of being reported in the course of their judicial function, that is very difficult to achieve. I suspect, particularly given some of the question analogies in this judgment, analogies are perhaps slightly unwise. But of course, there have been cases where magistrates with protected religious beliefs, for example, have found those protected religious beliefs come into conflict with their judicial function in, say, the granting of adoption orders to same-sex couples in a particularly high-profile case. The content of that established, defined right, you don't totally abrogate as a judge on judicial appointment, but in the context of your judicial role, you can't complain about being removed as a magistrate on the basis that you have protected religious beliefs. If that ends up being problematic for the overall role that you take or the broader administration of justice. So, my Lord gets to the very point of anxiety on which we have struggled, and which led, when his lordship indicated, even in the brief response to the permission to appeal application, that he intended to apply the architecture of the 8-10 balance to the question of judicial anonymity, we appealed on the basis that that could not be the appropriate framework for that particular decision. And of course, that distinguishes it from the position in relation to others who have a public function, but where it's established that social workers or clinicians or experts might conceivably come within the Article 8-10 framework, where, of course, we're acutely aware that the decision in Abbasi is being reviewed by the Supreme Court. And so to a degree, that there may be more cause for deference in relation to proceeding on that, and the review framework may be of more assistance. But my straightforward submission on Abbasi, insofar as it's relied upon, is it does assist us in terms of how you capture and calibrate the degree of risk that might be said to arise from social media activity, even social media activity of an unpleasant and pointed kind, and even that might include nebulous and not particularly grounded threats. But what Abbasi doesn't touch is the question of judicial anonymity, and of course that's a glaring omission if that's the framework, because in each controversial end-of-life case is a judge sitting in public. So I hope, though I'm happy to further that broadly deals with the submissions I make about the appropriate framework. I wonder if it assists the court, it isn't a lengthy authority. We do have the decision of Mr. Justice Leven in the Marsden case. That's within the authorities bundle at 353.
So, I mean, paragraphs 90 and 91 in Abbasi would, well, paragraphs 83, 90, 91 would suggest that Article 8 rights, which you accept are apply to everyone, might include adverse, hostile social media reaction. And does that not suggest that the box is already open?
Well, no, because
if you fear that,
because even if that might ground an incursion into Article 8 rights, what is difficult is to see that as a consequence of a publication of a name in the context of that public judicial function, and the expectation that name on its own is enough to to open that box. We say that...
But we know from Lord Roger that a name gives a great deal of colour to press coverage.
Well, that's the importance under Article 10. I agree, and absolutely pray that in aid, and that is why in the overall firmament of open justice, of which the judiciary are not just a part, but arguably the integral part of open justice.
I understand all that, but I'm just coming back to the point that I put to you, which is that the box is not even open. In other words, there is no balancing exercise to undertake because no Article 8 rights are engaged. I'm just looking at 90 and 91 which obviously doesn't apply. It's not talking about judges.
No.
It's not weighing in the balance the public duty of the judge and the job of the judge to sit in court and be identified as the judge in the case. But nonetheless, if we were asked to say that Section 6 you didn't even get as far as balancing Article 8 at all, then that might suggest something different.
Well, except that where Abbasi arrives at is paragraph 92. This is about the threshold of engagement that flows from the parents' proposed discussion of events, and that's why, again, what I delineate is the ability to exercise that prior restraint jurisdiction on the basis of Article 8 for reporting of the fact of a judge's participation. That is distinct from any steps that might be taken to protect against a particular incursion that might flow and be different, that might arise within the context of harassment, even if that harassment didn't reach the level of Article 2 and 3. So that's why I have sought to delineate that I'm not suggesting that judges abrogate all Article 8 rights or all potential theoretical reliance on Article 8 rights. What I am concerned about is the application of that Article 8.10 balance to a position of prior restraint of factual reporting of a judge sitting in a public arena. And that, conceptually, is the difficulty of seeing how that engages Article 8 rights at that level. And that is, of course, the application. Well, it wasn't an application. It was the situation the judge created.
Is at the words "at that level." I mean, the difficulty in this case actually is that once you have an exercise to undertake, then it's hard to see how you should undertake it properly without asking for a lot of evidence and asking people what they think and blah blah, and that is time-consuming, difficult, and frankly very harmful to Article 10 itself.
If I add to that, the strand that I was going to conclude on is, of course, the impact of that on Article 6, in the sense that if that approach is taken and is so utterly impossible to restrain and so utterly corrosive to public trust and confidence in the judiciary, then that might very well be an absolutely proper basis to take account of why there is a sharp distinction to be drawn.
Say that again.
Well, the impact on Article 6 of not naming a social worker or an expert may be said to be pretty remote. But if this court sets up a jurisdiction that opens the box to the consideration in multifarious contexts, not just the family division, but in all sorts of situations where there might be some purported engagement with Article 8 rights, what I say is that as a constitutional position, engages Article 6 as well, in the broader administration and confidence that the public would have in the administration of justice. If that public function is potentially being screened off in that way. And that might be said to be a distinction between those matters where Abbasi applies and a situation here where it doesn't. and on that basis, that the conceptualisation of engaging with protection of judges in different contexts, whether it's the administration of justice, whether it's profound risks.
I'm sorry to interrupt you, but you say effectively that there cannot be an infringement of Article 8 rights of a judge just by naming the judge as being the person who decided a particular case.
And insofar as that is associated with protected media commentary on the fulfilment of their function, which doesn't descend to criminal conduct, harassment, and so on, that I say is where there is the
No,
difficulty.
I mean, there's a completely different question. If there is serious threats and if there
I agree.
are serious criminal conduct, then the judge may have causes of action. The Article 6, Article 8, Article 2, 3 balance may be very much engaged. But you say that simply naming a judge who sat in a case in accordance with that judge's public duty cannot engage that judge's Article 8 rights. I think
Yes.
you have to say that. Otherwise, you see, once you
No,
get to a balance,
No, I suspect what I go to is why Article 6 might underpin that as a
Yes, you-
as a
I
point to
understand
arrive
that
at.
argument, yeah.
And of course, this is the relevance of the fact that even where they're sitting in private, there is no distinction between the fact that all judges sit on publicly available lists.
What, just explain to me why Article 6, quite how Article 6 comes into this, because Article 6 confers a right on a person involved in litigation to have a public hearing in the determination of their civil rights and obligations. No one's asserting this.
No?
And the judge never said that this is necessary in order to protect the rights of the parties to the litigation, the children or anyone else. So I can see open justice as a common law principle is an important, potentially important factor here in various different ways. But Article 6, wasn't the judge right to pay very little attention to Article 6 because it wasn't really a relevant matter on the facts of this case?
Well, on the facts, I agree. The preservation of Article 6 protections might be what could lead, as in the case of REW, to an order under Section 4.2 to defer publication of a judge if their identity was particularly significant and it might compromise the proper administration of justice were it published. So to that extent, you can conceive of engagement with Article 6. I suppose the point I was making was that there's a broader importance in maintaining public confidence in the judiciary and the judicial process that is an aspect of Article 6 that is which is potentially engaged in the opening of this box to.
That would bring you into those curious words in Article 10(2) about maintaining the authority and impartiality of the judiciary. It would be the authority bit, I suppose.
But we say the invidious nature of the exercise that might be engaged in, where you might be inviting judges in. Does a judge deal with their own anonymity? Does a judge in a leadership position, as Mr. Justice Williams was for a number of years, make determinations about those who he held that leadership position and pastoral role for? Those create deeply invidious and corrosive choices that we respectfully submit shouldn't arise. I think, obviously, what I pray and aid, albeit they are extrajudicial observations, is the former Lord Chief Justice saying that, and I suspect it goes to my Lord Justice Warby's point about the common law tradition and how it weighs within this balance, that anonymity for judges is not known. What Lord Burnett in that instance was highlighting was that there was a particular concern about decisions arising from Strasbourg where there was no known judge, and that was essentially antithetical to the common law tradition in this country. And if that is correct, then the step that Mr. Justice Williams took amongst its many defects, might be said to be beating a path away from very well-established principles. I think in the course of the broader presentation, I think the court probably has my submission on why I say, having developed all of those points, the judge's decision ultimately was wrong, in that we say there was a want of jurisdiction. He didn't apply the right framework. But even if the court ultimately is against me and accepts the position that is advanced by the local authority and the advocate to the court, that there might be some theoretical exceptional capacity to undertake that balance through the prism of Article 8.10, the deficiencies of the process, the want of evidence here, still render that decision utterly unsupportable, and one that was wrong on a number of procedural levels, but fundamentally was not justified when one applies properly the categorization of potential social media harm, the degree to which one delineates between the consequences of reporting and those of separate actors that may arise separately, that in each of those cases, the principled hedges that apply, if Article 8.10 is the appropriate framework, should have inclined the judge to particularly step back from the precipice when he was undertaking the review of his decision. But I'm happy to develop that further. And I say again, it feeds into the tension. Again, if the court is against me on the architecture of the interplay between the potential rights that might conceivably arise, that if the judge is envisaging this as an exceptional circumstance, that comes into deep tension with the wholly generic foundation for the decision in the particular case, and all sorts of additional difficulties, such as the tangle the judge gets himself in by undertaking what we say is probably an illegitimate process in any event of undertaking a broad after the event review of how proceedings had gone, and that somehow feeding into his framework. Does a more or less culpable judge tend to be named more or less frequently? Does the fact that they're more culpable lead to the potential for more harm? Does the fact that they're less culpable lead to less the tangle that the judge gets himself into? I say goes to the point that he obviously didn't assist himself in the process that he followed, and the judgment is.
Well, I mean, you say he simply forgot the need for accountability, scrutiny by the press, and transparency in all judicial proceedings.
They are striking omissions, or the conceptualization of them is difficult. And of course, it has been noted. But if it is true that a judge exercising a family jurisdiction is the equivalent of the lookout on the Titanic rather than the captain of the ship, the analogy is problematic.
Analogies are always problematic.
I've no doubt they are unlikely to appear in substantial form
There will be no analogies
in the judgment to come.
Judgment that I produce, even if my lord descend to them.
We'll dream one up. If you're leaving jurisdiction in this aspect of where the convention rights come in, I wonder if I might raise one thing which you may want to think about over the shorter adjournment, if that's all right. So we've got Section 12 and Section 97, and those are the statutory restrictions, then they're automatic restrictions. There they are, family proceedings, no negotiation, you don't need an order, they're there. That's right, isn't it? All right.
Yes, in the currency of proceedings in relation to Section 97.
So, yes, of course, 96, of course. So we then have the C66 from Ms. Tickle and the C2 from BBC, who are wanting the court to consider lifting or varying the restrictions, those automatic restrictions.
Yes.
And so there has to be a route by which they do that. And they, of course, use the President's guidance But that, and this is where I'd like some help, is I think that must be through the family proceedings rules, practice direction 12I, which is the rule which says that you've got to conduct a balancing exercise looking at convention rights in order to make a reporting restrictions order.
Yes.
To lift, vary, and in fact, that rule is, I think, to in the President's guidance. And that is bolstered or supplemented by a rather difficult to find, just for everyone that's planning their lunchtime, guidance issued by CAFCAS originally in 2005 and subsequently in 2015, which is supposed to inform, again, this is all the President's guidance when you then go on to it, which tells you how to go about it, but also talks about the scope of the reporting restrictions orders that would be made under Practice Direction 12I. Now, I think everyone's accepted that the starting point is that all these restrictions are aimed for the protection of the children and the integrity of the proceedings. But upon my reading of the scope, and I have to say it was this morning, so my apologies that you haven't had notice, is that it's very clear that it's about the protection of the children and the integrity of the proceedings and not the protection of an individual.
Yes.
So my question is, as PD 12I talks about making the application, which I think must be the route, that the procedural route that actually has been followed by Ms. Tickle, and
Yes.
refers to the balancing exercise under convention rights.
Yes.
But the guidance says, but not individuals, it's all about the protection of the children. How does that fit in with where Article 8 rights of the judge start?
So I suspect the point that I would fall back on is the delineation under Section 12. So the parties to the proceedings and the child are principally the child, and to a degree the parties to the proceedings are protected by the restraint on information relating to the proceedings, and so their Article 8 rights, which is the basis, or Section 12 gives expression to that protection of that aspect of a private life, is engaged. And so in the event of a reporter making an application, they have to give proper notice to those parties, because those parties' Article 8 rights are always going to be engaged by the potential dissemination of that information. But where I draw the sharp delineation is,
so your analysis
other people are not protected by that, so it doesn't arise.
So your analysis is the reference to the convention rights is picking up from Section 12.
I say it's confined to those who are
and
impacted.
clearly doesn't relate to the judge, because we've got 12.3, and then we've got the practice guidance, which specifically says the scope is relating to the
Yes.
not an individual.
Yes.
And you'd say that how that fits in.
Yes.
Okay.
Of course, various people, including theoretically a local authority, as in this case, would be on notice of a journalist's application. They may take steps pursuant to whether it's some obligation to an employee rather, or it might be a guardian in their own right. They may take steps aware that nothing protects their identity within Section 12, and that absent a proactive application for a reporting restriction order, if there is publication, they can be named, because they've always been capable of being named, then they can take any steps that they need to. And what I would say on a principled level about that is that is what the local authority, for example, in this case, should have done if they were going to ask for protection for certain social workers. Now, as it happens, the judge granted them that relief. It is not before this court. There is a review mechanism. But my lady may have seen the slightly pointed reference to Mr. Justice Williams in his June judgment engaging in an implicit criticism of the fact that my clients initially approached the court directly, informally by email to find out who the judge was, were told that their request would be moved to Mr. Justice Williams. He then takes a very refined procedural approach to say, well, the President's guidance doesn't permit informal applications, particularly in an issue of this importance. They should have made an application. Miss Tickle and Miss Summers did make an application, so did the BBC. The holding of procedural feet to the fire applies to the journalists. It's emphasised here that you have to give notice to the parties, and they have done so. But there are obligations if one is making a reporting restriction order, and that includes, under the practice direction, to give notice to potentially impacted media parties. The application should go through copy direct and so on. There should be notification to media parties. All of that procedural compliance is entirely lost when the judge, on an oral application, without proper application, simply makes that sweeping order. I mean, it's an aside in the context of professionals. That isn't an issue before the court. I'm not asking the court to rule that order. But it does go, in my submission, to the importance of what is sauce for the goose is sauce for the gander. If the press are having to comply with these requirements, then the parties, who are all parties to the proceeding, should do. And in this case, it touches on what I say is an approach that is entirely the wrong end of the telescope.
Mr. Barnes, I think we'll continue
Apologies.
with that at 2 o'clock. But you might look at 1.1 of that Practice Direction 12I, which says that it applies to applications for an order restricting publication of information about children. So it's hard to see how it was made, but maybe it was. I'd quite like to know. First of all, I'd like to be provided of a electronic copy of this, although I've got it on my screen.
Of the practice direction.
Practice direction and the CAFGAS guidance. And secondly, I'd just like to know whether that was the basis of the application.
The application was a C66 the application was a C66 invoking the inherent jurisdiction as the means by which the court relaxes those reporting the statutory
Yes, but
restrictions.
was it made under that practice direction?
I'm not.
Well, we can tell me at 2 o'clock.
they should.
I shall abide my soul in patience. For
I hope the
1
answer is
hour
worth the wait,
between
but
now-
it may not be.
Okay, 2 o'clock. Thank you.
Court, rise, please.